We're recording, and this is tape 4, and this will be the closing statements by both sides.
Okay.
You'd like to begin? Employer goes first.
All right. I'm Jesse Osthoff, and I'm a representative of management.
And Jesse, I'll need you to speak slowly and towards the mic so that the mic will...
All right. Management would like to inform the arbitration that the collective bargaining agreement states that employees are required to work overtime, and that management was not permanently changing Jose's work hours, so the matter did not need to be bargained over, which rebuts Jose's filing of a grievance argument. And further, we would like to state that neglect is an exception to progressive discipline, and that he could be terminated for that.
So your closing statement is simply that, first of all, that you didn't need to bargain the change in hours of the grievance. Is that correct?
Yes.
And then secondly, that you believe that by not coming to work and filing a grievance, that the employee was negligent?
Yes, that is correct.
Right. And as a result of the negligence...
No, neglect.
Okay.
Sorry.
Of neglect, but that would mean that the employee was negligent, correct?
Yes.
All right. And the negligence was what?
Not showing up.
Okay, not showing up for work. And for not showing up for work, one time that the discipline was discharged.
Yeah.
Okay. Thank you. And then the closing argument of the grievance.
My name is Stephanie Ewer, and I'm representing the union. After reviewing the evidence and listening to witness testimony, it is clear Mr. Garcia did not voluntarily quit and was discharged unfairly. We request that he be reinstated based on the following facts. 1. The employer violated their own disciplinary policy by failing to give Mr. Garcia a written warning prior to termination. Other than an occasional tardiness, Mr. Garcia has been a good employee for the past 3 years and has had no serious disciplinary action taken against him. 2. After filing his grievance on October 28th, Mr. Garcia informed his supervisor his intentions of keeping a second job until his grievance regarding the new schedule was heard. At no point did his supervisor or any member of management inform him that this would be construed as a voluntary quit, and in no context was such language constructed in the contract or prevailing precedent set. 3. We ask that the arbitrator consider Shaw 1, found in the evidence book, where an employee was terminated for failing to notify their employer of their absence. Similar to this case, there was contention on whether or not the employee had properly informed his employer about his absence. The arbitrator ruled in favor of the employee, agreeing that the employee did not have the intention to quit their job. And although he did not follow procedure, the employee made an effort to inform his supervisor of his absence. Mr. Garcia made an effort to inform his supervisor of his intention to work his normal work schedule until his grievance was resolved. It is unreasonable for the employer to assume that Mr. Garcia no longer wished to be employed by Flowers for Smiles. In the matter of the new work schedule, we ask that the arbitrator consider Mr. Garcia as a family man who supports his wife and 6 children. Management believes that forcing Mr. Garcia to work 10 hours of overtime with only a week's notice is reasonable. However, we do not believe a week is long enough time for Mr. Garcia to make alternative arrangements for his second job. When he brought to his concerns to his supervisor, Mary Snips, and explained his needs to keep his second job, Mary was unwilling to assist Mr. Garcia in his dilemma. That's all.
Thank you. Typically what I ask, it's up to you, is that you can also file briefs, and I would suggest that perhaps both sides file briefs in this matter before I make a decision. We'll have 30 days to file the brief. After I receive both briefs, we can discuss how we'll cross-file those afterwards, but you send them to me. And then I will write a decision within 30 days of that. So there will be a decision within 60 days. The things that I'd like you to focus on are basically that your version of the facts, also any arbitration decisions that you'd like me to consider. I see the issue as one of, and we can talk about this right now. There's a common tenet in labor law, which is work first, breathe later. which means that if you have a grievance, you still have the obligation to work, except if there's a safety issue or a legal issue. So you have that on one side, and then on the other side, you have an employee who is saying, I did not intend to quit. I didn't see this as anything other than I was working my other job, and no one else has been treated in this fashion. And you have a supervisor who has readily admitted that typically they use a first warning, a letter of warning, and that has not been received. So there's a uphill battle for both sides in your in your briefs. And those are the issues that I'd like you to address. After we stop the recording, I'll go through some other issues with you. Do you have any questions before I stop the recording? Okay, thank you very much.